our communities in our state, I happen to represent the wonderful town of Conway that has also passed a workforce housing ordinance. And I think we need to see more of that, but we have to lay the groundwork for the ability of towns to move forward and try to incentivize affordable housing. And I think that Senate Bill 400 tries to create that partnership, a predictable process, a knowledge of the problem of how we move forward. So if I might, Mr. Chairman, I'll just briefly touch on the provisions of Senate Bill 400, and without going into in-depth explanation, I think Ben Frost is prepared to do that, touch on why. The first section, section 1 of the bill, calls for voluntary training of Board of Adjustment and Planning Board members. So obviously you have the ability to have a discussion about what's happening in other communities, what the problem is, what works, what doesn't work through the training process. That's voluntary. The second provision deals with transparency of fees. I think this is a pretty reasonable request so that anybody that wants to establish affordable housing is to provide the same incentives that if you're going to provide incentives as a town for senior housing, that it be provided for workforce housing. And I would go on to add on that if there's inclusionary zoning, then affordability criteria need to be established, and that's at the beginning of page 2. The fifth provision is that when a decision is rendered by a planning board or a board of adjustment, that they adopt with it a finding of fact. I think that's really kind of common sense given our litigious society today, but it certainly, by requiring it, makes the opportunity for every applicant to know what they're facing. Section 6, regulatory time review. This is a critical issue in terms of trying to get through a process knowing that there's a predictable outcome of how an application is going to be viewed and a timely enactment or review of that. Definition change of workforce housing, that if it's going to be workforce housing, that the age restrictions in line 7 on page 3 are similar to senior housing. Section 8, I'm going to let Ben Frost talk about, but it's meant to streamline what sometimes can be a cumbersome process with a Board of Selectmen. Then moving on to sections, oops, what did I do? Section 9, calling for expedited review of any decisions that may be challenged in either Superior Court or the Supreme Court. Given the importance of housing issues overall to the state, I think it's reasonable to ask that both the Superior and Supreme Courts review things in a timely fashion. There's language on posting a bond if there are challenges, to make sure that we don't encourage a lot of frivolous lawsuits that are seek to delay a development process through litigation. Section 13, Tiff financing, section 13 and 14, I think we've seen, you know, in particular in the transportation sector, use of Tiff financing, which as I understand it, takes the expectation of future revenue through a tax process based on rehabilitation and greater property value to fund the current development. It's a tool that would allow municipalities to move forward with that kind of creative financing. There is a sentence that precludes the ability of a town to use eminent domain for that purpose. And then lastly, the New Hampshire Housing Champion Certificate. I think this is a good idea to have public recognition for communities that are moving forward. As I said, Conway did, and presumably they would be eligible for one of these certificates for what they've done, and sort of a thank you for a public recognition for that kind of process. So that's a very quick thumbnail sketch. Elliot Galt is here for the governor's office, but there is a letter that I've submitted to the divisions. It doesn't seek to overtake a town's zoning, but it seeks to try to create a partnership that will enable the development of more affordable housing. Again, I think we've done an awful lot here in terms of funding. It's my hope that with this legislation, and if we can successfully pass it and hopefully convince our friends in the House to pass it, we're going to better create a partnership with the 230 plus communities throughout the state to develop what is absolutely essential if we're going to be a growing, prosperous state. So thank you, Mr. Chairman.
Thanks, Senator. Do I have any questions from the committee members? Senator.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill forward. Just have a couple of questions. On page 1, section or procedural incentive under this section for the development of housing for older persons, it shall allow the same incentive for the development of workforce housing. The municipality doesn't want or finds a way around it, they're going to actually reduce the number of adult communities as well?
Well, it would be my hope that towns don't do that. I think if you're going to, the provision is for if you're going to have this kind of inclusionary zoning ordinances, that they be favoring both senior housing and workforce housing. I think both are really important and both should be encouraged. It should hopefully not be an impediment to either one, senior or workforce.
Certainly.
In the, on page 2, section I, it says the decision shall include specific written findings of fact that support the decision. Failure of the board to make specific written findings of fact supporting the disapproval shall be grounds for automatic reversal and remand by the Superior Court. Isn't that why we have the Housing Appeals Board, to deal with things like this?
It is, but I think the hope, and again, I think perhaps Mr. Frost can address this more than me, but as I read it, the hope is that by a zoning board or a planning board giving the reasons why either they approve or disapprove, or it would either be one of those, with a findings of fact, that expedites and justifies, quite frankly, but also expedites whether it goes to the Housing Appeals Board or to the court.
Thank you.
Additional questions? Thank you, Senator.
Thank you.
And since Ben's name has been mentioned several times, we will call our representative from New Hampshire's housing, Mr. Ben Frost.
Thank you, Mr. Chairman. Good afternoon, committee members. It's a delight to be back before you. My name is Ben Frost. I'm with New Hampshire Housing, and I'm here to express New Hampshire Housing's 400 and thank Senator Bradley for introducing it and explaining the provisions of the bill. I've submitted to you a letter from our Executive Director, Rob Dappas, that outlines our support, that details the issues related to the housing market that Senator Bradley so ably described. One number I'll share with you that was kind of startling to me when I was preparing for a presentation a couple of weeks ago was we typically look at the monthly median sales prices and compare them year over year. Well, I decided, well, why don't I go back 2 years? Between December 2019 and December 2021, the median sale price for homes in New Hampshire has gone up 33%. This is a stark indicator of the housing supply problem we have here in New Hampshire. There's not inventory for sale for realtors to sell to buyers who are ready, willing, and able to buy otherwise. And this is also mirrored in the rental market with its extraordinarily low vacancy rate, below 1%. For many years, I eschewed the term crisis because I think it's overplayed. Ladies and gentlemen, we have a crisis in our housing supply right now, and as Senator Bradley indicated, quoting the BIA's editorial, this is a long-term problem that has the potential to have long-term negative impacts on our economy. And we have the capacity to do something about it, and Senate Bill 400 does something about it. It's not a panacea, it's not going to solve the problem alone, but it is an important step in the right direction. What I'd like to do is I'll address the couple sections where my name was invoked, and then I'd be happy to take your questions as well, and I have a couple of points I want to make as in addition to that. Turning to Section 5 of the bill on page 2, this is starting at line 12. Senator Birdsall, you had asked, isn't this the role of the Housing Appeals Board? And yes, it is, but this is specifically directing the Superior Court to remand in the absence of findings of fact. As the chairman knows, I've been advising local boards for the better part of 25 years here in New Hampshire. And one thing that I have always said to them, whether it's planning boards or zoning boards of adjustment, you really should be doing findings of fact, especially where you're denying an application. After all, the applicant who's coming before you has the right to know why you're saying no, rather than having to sift through the minutes to try to figure it out. Likewise, a reviewing judge has, well, I don't want to say the right to know, really should be able to tell what the reason is for a denial of an application. It is to the benefit of a municipal board to spell that out in findings of fact. This makes it law, saying you must do findings of fact, especially where you're denying an application. And that's good for the planning board and good also for the zoning board of adjustment. With regard to Section 8 of the bill, this is on page 3, starting at line 9. This is a long section. This is from a planner's perspective, and I'm a professional planner, have been for 35 years. This is probably one of the most vexatious statutes for planners. It is tough to get through. It's not, well, it's been pieced together over time so that it, if you follow it letter for letter, it works, but it is hard to follow. What is attempted here is an effort to simplify the statute a little bit by removing provisions that are never used. And so the language that is proposed to be struck here these are the provisions that I've talked with planners in many different communities, and I've asked, well, has your town ever used this provision? And the universal answer is no. So what this does is it'll have no practical change in how things are done at the local level. But it will eliminate steps in the process that are never used. The consultation with the select board, for example, and getting the additional time needed. Because when an applicant is appearing before a planning board, and this RSA 676:4 is related strictly to planning board. This is called board's procedure on plats, meaning applications that are before a planning board. If the planning board can't complete its review within the statutorily required 65 days, it's going to ask the applicant for additional time. And almost always, that applicant is going to say, yes, I'll give you more time, because the applicant wants to get to yes and doesn't want to alienate the planning board before which it has its application pending. If the applicant says no, and there's not sufficient information for the planning board to make its decision, that's why it's asking for more time, then the planning board can deny the application legitimately because it doesn't have the information it needs to make the decision. So the additional steps that are in the statute that are never used are in fact unnecessary. And so what is proposed is to remove those things, to get and to clearly spell out that the planning board, in the absence of sufficient information, can deny the application without prejudice, meaning that the applicant could come back, file a new application, pay new fees, and hopefully, for the planning board's benefit, provide the information that was sought, the absence of which was the basis of the denial in the first place. I do want to comment also on Section 13 of the bill. This is on page 5, starting at line 15. And this has to do with the existing RSA 162K, which is the Tax Increment Finance District Statute. What is proposed here is enabling, and much of this bill is enabling legislation for municipalities. What is proposed here is enabling legislation to give municipalities, if they want to use this statute to create a TIF district, to enable them to use TIF districts for the creation of affordable housing. This is done in other jurisdictions. Maine, for example, has it explicitly enabled in its TIF district statute. New Hampshire has not ever had that. And so where a developer is dealing with bank financing, and they're working on a development in a TIF district. So if that were affordable housing, the bank would say, where's your statutory authority, municipality, to do this? And it's not clear under New Hampshire statute. Arguably, you could do it, but it's not sufficiently clear for bank's purposes to bank on it, if you will. What's different here from the past iterations of this legislation, and this is the third time around, twice before, this legislation has started in the House, but here we are in the Senate this year. What's different this year is the reference to the powers of eminent domain. And last year in House Bill 586, which was essentially this bill with some changes this year, it made it to the floor of the House, and one of a criticism levied against this, and this was by Representative Barbara Griffin, was that a municipality could use eminent domain to take private property for the purposes of affordable housing. And she was right. And so we sought to address that this time around, to make it clear that a municipality cannot use the powers of the Tax Increment Finance District Statute, RSA 162K, for the purposes of developing affordable housing. I think that was a remote possibility. And in fact, under New Hampshire law, it's really difficult to use eminent domain, especially following the infamous 2005 decision of the U.S. Supreme Court, Kelo versus the town of New London, Connecticut, where private property was taken by a public instrumentality and then transferred to another private property owner for the purposes of economic development. I did say it was infamous. And the New Hampshire legislature responded the following year, I think, and changed New Hampshire's eminent domain statute to prohibit that private, public to private sort of transfer using eminent domain powers. So that can't be done in New Hampshire, but this makes it crystal clear that regardless of who the parties are involved, you can't use the Tiff statute for affordable housing development. I could go on, but I'm happy to stop for questions if you have any, and there may be some other things we want to talk about as well.
Questions from committee members? I do. On page 2, where it does talk about automatic at 18, I don't believe that the casual reader is going to read the legal interpretation of that. Could you put that in? I believe it's a court that still has to make the judgment of whether there will be a reversal or not. Could you take it out of legalese and put it in plain speak?
Well, you're talking about section 5, Mr. Chairman, is that right?
The grounds, line 18, we're talking
Line
about
18, okay.
automatic reversal.
So shall be grounds for automatic reversal. I mean, it is still at the discretion of the court to decide whether they want to reverse or not. But if the court deems that it is appropriate under the circumstances, then it could say, you didn't do findings of fact. I'm reversing and remanding. Go back, do your findings, and do it right.
Yeah, I just wanted to make sure that that was clarified. Senator?
Thank you, Chairman. And thank you, Ben, for testifying with us today. I just wanted, for the record, to clarify, is there anything mandatory for our municipalities in this bill?
Senator, yes, there are a few mandatory things. So the findings of fact provisions has the effect of being mandatory because it's grounds for reversal if they don't do, if the planning board or a ZBA doesn't do findings of fact. I would say it should not be a heavy lift for a municipality, for a planning board or a zoning board, especially where they're denying an application to do findings of fact. It's fundamentally fair, and this is saying you really, really need to do it. There are, let's see, the provisions dealing with the timeline for planning boards, this is a mandatory timeline, and it's removing a couple of steps, so there's nothing additional for a planning board to do. And I think that may be it for the mandatory sections. There are a couple things, other things that deal with the courts. But I think this is primarily tools for municipalities to use at their discretion, such as the changes to the inclusionary zoning statute. If a municipality wants to, and this is, I'll refer to that by section, this is in, on page 2 at the top, line 1, that paragraph, this is the existing inclusionary zoning statute. If a municipality wants to, it can require under this, or could require under this, the development of affordable housing, provided that it didn't make the development less profitable for the developer. And that would result in an iterative negotiation process between the planning board and the developer. And you see on line 10 of page 2, starting in line 9, actually, that sentence, such ordinances shall also enable the planning board to waive or modify in individual cases any standards that are demonstrated by an applicant to render a development economically infeasible. So that if a planning board were, or if a town, through its zoning ordinance, through its inclusionary zoning provisions, if it were to require the development of affordable housing, a developer could come to the planning board and say, yes, but what you're requiring will make this development unprofitable and therefore unbuildable. And the developer could say, if you waive this provision, then it would become profitable. Or these series of provisions, then it would become profitable and I could proceed with that, which would make the planning board's or the town's exercise of this requirement a legitimate exercise. Right now, towns cannot require developers to build affordable housing. It is a under the existing definition and standards for inclusionary zoning, it is a voluntary incentive intended to induce developers to build affordable housing. That's the law right now. This is saying municipalities can require them to do it, subject to that profitability caveat.
Follow-up?
Follow-up. So just to clarify, just to make sure it's crystal clear what you're enumerating, this legislation doesn't in fact require any housing to be built. It doesn't require a municipality to pass any zoning, but it does enable a municipality to pass that zoning with a degree of flexibility built in.
Exactly, Senator.
Okay, just one more question if I could, Chairman.
Absolutely, Senator.
And Mr. Frost, could you just remind the committee, I know there's a housing needs assessment going on statewide now to come up with an updated number, but could you share with us the most recent number that New Hampshire Housing had published for the number of housing units needed in our state?
Yes, and that is in our letter from Mr. Dappas. We did work with Russ Tebow a couple of years ago, and it was preliminary work on our statewide housing needs assessment. And based on current conditions then, 2019, he determined that there was a gap of between 15 and 20,000 housing units, simply to meet the current market conditions, to stabilize the housing market, not anticipating future growth and needs for a growing labor force, but just to stabilize the then current housing market, 15 to 20,000 housing units for purchase, for rent, total. That would bring the vacancy rate up in the rental market to something that is more balanced between the interests of tenants and landlords, and the for sale market that more balances the interests of buyers and sellers. Right now, as you know, this is a very strong seller's market. So if you're selling your house right now, it's great as long as you don't need another place to move to, unless you're going to Palo Alto or someplace else, or you have a second or third or fourth or fifth home to move into. If you're selling a house and you need to buy in New Hampshire, it's pretty tough out there. Likewise, if you're a renter looking for a place, it is really tough out there. Thank you.
Additional questions from the committee? All right, thank you, Mr. Frost.
Thank you very much.
All right, let me give you the status. All right, there's only one person signed up opposed. He has chosen not to speak. We have 2 people that have signed up because of their positions, not taking position on the bill. I'm going to take both of them, and the rest of you support the bill. So if you want to take a minute or two to pare your testimony down, and if you've already provided written testimony, then just get up and wave at us. It would be appreciated, but you will be called on. The next one on the list is from our judicial branch, Mr. Head.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not have any position on the policy in this bill, but it does, as has been referenced in the earlier testimony, implicate process and procedures within the Judicial Branch. So I wanted to come simply to provide some information relative to what that means for the Judicial Branch. And also make a reference to Representative Lynn's bill that, if it crosses over, addresses many of these issues, which is House Bill 1389, which I'll speak to briefly. Currently, there are about 13,500 cases pending in the Superior Court. About 60% of those are criminal, about 40% of those are civil cases. The criminal cases obviously have a priority on the Superior Court's docket and need to be addressed in accordance with constitutional requirements. Other factors that influence the Superior Court's docket, in addition to criminal deadlines, cases that involve things such as temporary restraining orders, injunctions, emergency measures of all sorts, warrants, whatever, various things may come up during the course of a day in addition to sort of the average caseload that every Superior Court judge has. Of those, taking the 13,500 cases, that means roughly about 700 cases per Superior Court judge. We have 21 judges, I believe, and that's set by statute. So this is a busy place, and you can compare that to the Circuit Court, which is busier. They have 125,000 cases, but more judges. So in Superior Court, we're talking roughly current caseload, about 700 cases per judge. The current statute also says that appeals from planning boards and zoning boards of adjustment shall be given priority on the Superior Court docket, and that is done. And that is done, every day the clerks are putting together dockets based upon constitutional requirements, based upon the types of cases, and based upon statutory requirements. And there are other statutes that also impose deadlines upon the Superior Court. Right to know appeals, for example, have certain deadlines. So anytime we're adding deadlines, it creates significant ripple effect complications throughout the Superior Court. So I just simply want to highlight that and note it, because this bill, as written, would impose very specific 90 and 120-day deadlines. The other aspect of this is, when those deadlines are being triggered by. The record needs to be transmitted to the court, and these deadlines are not being set by the date that the record is being transmitted to the court, but by the date essentially notice is going to the towns. And so the reality is those deadlines are actually shortened because the record hasn't actually fully arrived to the Superior Court. The other aspect of this bill, which is a very specific technical change that we're requesting, is with regard to the effective date, which I think is currently upon 60 days after passage. There's actually a statute that governs effective dates on bills. RSA 14:9-A says each law affecting judicial practice and procedure, so on, et cetera, shall take effect January 1 following passage. We do ask, if nothing else, there be a specific amendment that it become effective on January 1 of 2023 in accordance with RSA 14:9A. And I also just wanted to briefly speak to Representative Lynn's bill, House Bill 1389, which would call for the creation of a land use docket in the Superior Court, have a judge appointed that would be for that purpose. It includes within his bill deadlines, and that essentially eliminates the issue or not issue, but the facts of sort of what is otherwise a remarkably heavy caseload for all of our judges, and would put what is obviously a very important issue a priority within the court system by giving it its own dedicated docket, similar to what we have now with the commercial docket. This would, under Representative Lynn's bill, provide a land use review docket to address what are these very significant, important issues that you've heard so far from the speakers and you'll hear from the others. So that is a mechanism which I at least received what appeared to be favorable attention at the hearing level at the House, would be another way of addressing these issues that are outlined in this bill relative to the timing and the deadlines. And then one last point I'll make, which I think is one of the questions Senator Birdsall had raised. There is at least an alternative mechanism for appeal of housing type of developments, which is the Housing Appeals Board, which does not involve the court system. And I have no information relative to their docket or speed of review, but there is, at least relative to housing projects, another mechanism or another appeal path. With that, I'd be happy to take any questions.
Senator Francois.
Thank you, Chair, and thank you, Mr. Head, for your testimony. I'm glad to have you here and to have raised these deadlines. So just a couple questions about your comments.
Sure, thank you.
I understand what you're saying about the deadlines, and the rationale behind those is because once a land use decision is given, for every month of delay to construction costs are going up about 1% per month. So it can significantly alter the cost of the program and change the financing structure to have to wait, additional months. So our intent with that was to support this state goal of housing. If we were able to clarify that those deadlines were dates set by the transmission of the record to the court, I guess, would that address your concern about there being specific deadlines in there? And then as a secondary portion of that question, if HB 1389 were to pass as written, if a separate land use docket existed, would you have any concern at all about the deadlines?
I'll start with the last question and work my way back.
Sure.
With regard to the land use docket, we do not have any changes or suggestions relative to the deadlines that were in that bill.
Okay.
So we would be fine with that bill as, with the deadlines as written.
Okay.
One of the other aspects of this is, this bill is not limited to housing appeals. There are some remarkably complicated and complex decisions that are coming out of planning boards
Sure.
that involve a significant record,
Sure.
complicated design plans, some very complex commercial developments that may come as an appeal to the Superior Court. These deadlines apply to those equally, and at least as written, have no provision for the parties to opt out of those deadlines. And so if you just take a sort of case process, it's filed, the record has to be transmitted, there is a hearing, usually either a scheduling conference or at least a evidentiary hearing or an argument that is presented. That hearing has to be worked within the other 60% criminal cases, 40% civil cases, the other 13,000 cases that have to get sort of worked in there. That evidence has to be presented and an order has to be written while the judge is still doing those 13,500, there are 700 cases. It is a significant workload, and then if you add on that an appeal that is a very complicated, design intensive, has multiple environmental issues, has engineering issues, whatever it may be, experts that are providing information to a judge, it is, and probably and possibly in some of those testimony that's being presented to the court from experts becomes very complicated and can take time, which is different than perhaps a small housing subdivision, which may have abutter complaints. So, as written, the bill does not differentiate between the complexity or type of appeal that is being presented.
Sure.
So I probably didn't answer your question in any of that.
If I may,
I
Chair,
apologize if I
was going to
didn't.
clarify. I was just going to clarify.
I'm always a problem when I start with the last question. or
My
last part.
first question, yeah, was, but I think you did answer it. If we were to clarify that the deadline began on the date the
Yep.
record was sent to the court, I think.
Still, I think there's still significant issues
concern,
relative to that. And
Okay.
even if you look at Representative Lynn's House Bill 1389, it does provide for deadlines, but also provides an opportunity for the parties to say, no, we actually need more
Yeah.
time ourselves
Yeah.
to be able to present the case.
Provides them with that mechanism. Okay. Follow-up, if I may?
Yes, ma'am.
Chair, okay. And could you clarify for those of us that don't practice in the judicial branch, just a little bit, because we will hear, obviously, 1389 on its own, but would the land use docket, essentially, it would create a place where land use cases are all heard together, and, that way they are the priority because they're the only cases being heard, and that, by that set of judges, or?
No, what at least as written, as would be likely implemented is a judge would be assigned to it. That judge would hear all of those cases, develop some expertise and knowledge in that particular area, and it wouldn't have the same docket stress that you have
Yeah.
with the others that have to hear all the criminal cases, all the TROs, the injunctions, whatever else it may be,
Yeah.
so that they then have the time, even for the more complicated ones,
Right.
to be able to get those through.
To turn them around. Okay, and then just one final question, Chair, if I may.
Yes, ma'am.
Thank you very much. You mentioned that in the current docketing system, obviously without HB 1389, that, for example, a ZBA appeal is given priority. You said, that is done in the current docketing system. Could you just clarify that a little bit? Because then you made reference to just kind of arranging a daily schedule, and I don't know if that's a kind of priority.
Yeah, so
Intended,
the clerks set the daily schedule for the judges, and it goes out a period of time, and they're aware and have in our Odyssey tracking system that these are land use appeals. They're aware that they have to get priority. They get put in as soon as they can. But that said, if they have, so I'll take, for example, I looked at today's docket for the Merrimack County Superior Court. Didn't pick that for any particular reason. They have today scheduled 33, or two judges. One of them has 33 cases on their criminal docket. The other is 23. And they're all criminal cases today because those had the priority today.
Right.
Tomorrow, there could be two civil cases. So the docketing system that the clerks use have flagged land use appeal cases as needing priority. So once the clerk is deciding between this case and another, the land use case wins in terms of getting on the schedule, and the other case gets pushed out a little bit more.
Okay.
And that's always the case. Anytime you add a deadline, something else is going to get pushed.
All of that was really helpful. Thank you, Chair.
Okay, additional questions? Thank you very much. NHMA, Margaret.
Thank you.
Welcome, Ms. Burns.
Thank you. Good afternoon, everyone. I'm Margaret Burns, the Executive Director of the New Hampshire Municipal Association, and NHMA does not officially have a position on Senate Bill 400, but there are aspects of the bill that are very positive for municipalities and that do indeed support some of the member-adopted policies that NHMA has. NHMA has a housing policy adopted by its members. That policy states that NHMA recognizes the need for diverse and affordable housing in New Hampshire and the responsibility of each municipality to afford reasonable opportunities for the development of diverse and affordable housing. NHMA believes that municipalities should have discretion in how to satisfy this responsibility and supports legislation that enables municipalities to find innovative ways to do so. Consistent with that, we support legislation that allows municipalities to require the inclusion of affordable and diverse housing opportunities as part of new housing developments. We support financial and other incentives to municipality to encourage economic development and affordable housing. And we also support legislation and policies that encourage creative and flexible approaches to meeting future and current housing needs in our municipalities and in different regions. Corresponding with those, Senate Bill 400 creates new economic tools for municipalities to create affordable housing, specifically some of the changes to RSA Chapter 162K and 79E. It also creates the Voluntary Housing Champion Program that will give preference to qualifying municipalities with various funds and infrastructure funds. And it also requires that the state provide free training and resources to local land use boards, which is incredibly important to local land use boards being able to fulfill their responsibilities. It's also important to towns being able to encourage volunteerism, that they are able to provide that free training and access to volunteer board members to encourage them to be part of the board and create statewide mandates in an attempt to address affordable housing or other development type items. But there is too rarely not the policy, the state policy behind those mandates and the partnership behind those mandates. And Senate Bill 400 goes a long way to create that level of collaboration and partnership. So with that, that concludes my testimony, and I'm of course happy to take any questions.
Questions from the senators? Senator Ward.
Thank you, Mr. Chair. I've heard the word partnerships a couple of times now. Exactly how is that partnership going to take place, and who is the developer partnering with the town partnering with the state? I haven't seen anything specific how this partnership is going to work.
I think the way I see the partnership in Senate Bill 400 is first and foremost between the state and municipalities. The creation of the Housing Champion Program is a way that the state can certify and recognize municipalities that are willing to do more to encourage affordable housing. And in exchange for municipalities being willing to have those kind of policies and encourage affordable housing, they can get access to some additional state funds. There's also the partnership between the state and municipalities with the training that the state will be providing to municipalities, the free training. So that creates the support from the state to the locals. But there can also be, of course, partnership between private developments, private developers and municipalities with some of the economic development tools that municipalities can use that are created by Senate Bill 400. So I think there's both the state and local as well as the private local partnership opportunities that are created by the bill.
Yes, ma'am.
Thank you. I've been on the planning board, and I know how hard it is to make any changes. And it seems to me that, and besides, free training has been available. The problem is that you don't get very many people actually taking advantage of the training. So that's one hurdle. When you have something like this, I think it is very important to have the whole municipality behind, in which case I can see that if a proposal like this comes before the planning board, you have to invite the town to participate and have it listen to what the townspeople have to say.
Absolutely, and as you know, being on a planning board, amendments to zoning in most of our municipalities go to town meeting, which means that the public input, the public hearing, and the vote by the public is needed in order to make changes to the zoning ordinance. But you're absolutely correct that in order to make policy changes like this, it requires buy-in level of communication and work at the local level with residents to talk about changing policy.
Thank you.
Seeing no other questions, thank you very much. And remember, please, don't repeat the stuff that comes before. Mount Washington Valley Housing Coalition, Harrison. Come on up.
Thank you very much. My name is Harrison Kanzler. I'm the Executive Director of the Mount Washington Valley Housing Coalition based out of Conway, New Hampshire. And I will try to keep this as brief as possible. We are in support of this bill. Carroll County is facing kind of an unprecedented housing crisis right now. It started about 15 years ago as socioeconomic humanitarian issue and has exacerbated itself into a full-on economic crisis for the Mount Washington Valley. We've already heard citation of state median prices, so I'll skip that and go to a more local level for us as it pertains. Carroll County, just in the last year, saw an increase of 23.4% in its median home sale price. If we take that date back to 2017, there has been a 61% increase in the median sale price in Carroll County. That puts Carroll County as the 4th highest median sale price per county in the state, while it is number 9 for median income. Makes it very difficult for workforce in the Mount Washington Valley to find any housing at all. We have a 0.7% availability for rental housing, and if they want to transition into purchase housing, it is almost impossible because we also have a very low stock at a very high price for purchase housing. This bill will provide our communities with the abilities to, with a lot of tools, with the ability to create new innovative land use controls. As the senator said when he introduced the bill, Conway passed a density bonus inclusionary zoning ordinance. My organization created that bill for the town of Conway. And we can use what is in this bill to make that ordinance even better. The town of Conway is also currently working on a new bill, which will be a cluster ordinance, which again can be used together in concert with things in this bill to be even better. All of the communities of the Mount Washington Valley turn to my organization and ask us, what can we do? Members of the communities turn to us and say, what can we do? The planning boards ask us, what can we do? And we point them at this bill and say, there is a lot coming if we can get this through, if this bill is passed. It will do an immense amount of things for small rural communities like those in the Mount Washington Valley. And for that reason, we support this bill. I'd be happy to take any questions.
Thank you. Questions from the senators? Seeing none. Concord Coalition to End Homelessness, Ellen?
Thank you for the opportunity to testify. I'm Ellen Groh. I'm the Executive Director of the Concord Coalition to End Homelessness, and I'll give you this written testimony as well. I just wanted to touch on the fact that this doesn't just affect workforce housing. This affects the work that we do trying to end homelessness. Our organization provides crisis services to people, such as a daytime resource center and an emergency winter shelter, but we are very, very focused on trying to end homelessness through permanent housing. And we stepped our toe into housing development a couple of years ago by turning a downtown building into 4 apartments for people coming from homelessness. And I can say that that process was long and challenging for us, but it was successful. And the 4 people who are living there now came from literally the woods around Concord, and they would still be in the woods around Concord if we hadn't built that housing. The lack of affordable housing is absolutely impeding our ability to address homelessness. There's no place for people to move into, even if they have rental assistance in their hands. So this bill has a lot of provisions, you've already heard about them, that will help our organizations like mine and my colleagues across the state to address this homelessness crisis as well.
Okay, thank you. Questions from senators? Seeing none. New Hampshire Legal Assistance, Elliot Berry.
Thank you, Mr. Chairman, members of the committee. I too will be brief. For the record, my name is Elliot Berry. I'm the Director of Housing Justice at New Hampshire Legal Assistance, where I've represented low-income clients for over 40 years. I'm not a developer, never tried to develop any essential housing for people like my clients. Primarily, I want to address myself to Part 4 of the bill that would give a really, really important tool to municipalities when they want to use it. It is entirely locally, it's a local option, and that is the part that broadens the definition of inclusionary zoning from the current law that says it would be voluntary for a developer to mandatory. And let me give you just a quick example of how that works. Let's say you're in a market like Portsmouth, which I hope I'm not offending anybody, but that market is really, really hot. And so a developer comes in with a project that's, relatively upper income housing that's just going to make the market hotter and more expensive and may in fact directly displace a number of lower income people. That city under this bill could choose to say, look, Mr. Developer, or Ms. Developer, if you are going to do this development, you are going to have to set aside X% of the units for people who, of this area who can, that are affordable to them, even though they're of lesser means. It's a really important tool. No municipality is going to use it where there's not much housing demand. But as part of that toolbox, it could make a very, very big difference for overheated markets. I also want to say that the provision that says if you're going to incentivize housing for seniors, you also have to offer the same incentives for families. You've already heard the data. There are over 27,000 tenant households in New Hampshire today where the people are paying over half of their income for rent. We can't afford to let municipalities say, sure, we are going to incentivize elderly housing, and so that we can completely ignore the needs of all those workforce families and lower income families who are in desperate need of housing. I think the bill overall is terrific. I support it, and I hope you will too.
Thank you.
Happy to answer any questions.
Questions from senators? Seeing none, thank you very much. Home builders, Ari?
Good afternoon, Mr. Chairman, members of the committee. I'm Ari Pollack, an attorney at the Gallagher firm in Concord, here on behalf of the New Hampshire home builders. We want to briefly add our voice to the chorus of support for this bill. Our state has, the housing crisis in our state has reached critical mass, and the solutions are numerous and they're seemingly intertwined. All the ideas in this bill have been discussed either through prior legislation or through the Housing Commission. They're all sensible and they may well help offer solutions to this statewide concern. The third rail in these discussions is always the intersection of state policy and local control. And in this case, the ideas here are really about due process and efficiency and not the heavy hand of state government telling locals what they can and can't do. Many of the ideas in the bill are enabling. Put differently, a planning board or a zoning board has every ability to deny a project that doesn't comply with their regulations after this bill as it does before this bill. I've been a land use attorney in New Hampshire for 25 years, and this bill has the potential to be the single most effective piece of housing legislation that I've seen in all that time. The home builders ask for your support for the bill. Thank you.
And thank you, Ari. Questions from the senators? Seeing none, thank you very much.
My pleasure.
CDFA, Katie Easterly. Martley, it just keeps on going.
It does. Good afternoon. I'm Katie Easterly Marte. I'm the Executive Director of the Community Development Finance Authority. We're a public authority that's able to finance important community projects, including childcare centers, affordable housing, and downtown redevelopment. I'd like to talk both from my role in financing those important projects and also as the co-lead of the Council of Housing Stability. The council produced a 3-year strategic report in June of 2021, and it called for many and all of the provisions included in this bill as a way to create housing stability in our state, and over 3 years to really be able to reach the goal of building 13,500 new units, which is was stated previously will only be a piece of the solution in our state. I would also like to talk just about what we see as the Community Development Finance Authority in the development of vibrant communities across New Hampshire. We know that communities, in order to track a new economic path and to build vibrancy, they need to build housing and other economic development projects. I want to talk to 2 areas of this bill that will really improve the ability for communities to be able to build that economic future. Establishing the timelines and also the incentives that are spoken to in this bill. In terms of timeline, increased predictability is necessary in complex development projects like affordable housing. Projects which are transformative often take years to pull together and are layering together many sources of funding. And without predictability in the approval process, often that funding falls away and is not able to, and does not allow the project to move forward. So predictability is essential at ensuring that we keep costs down and are able to continue to build this necessary housing. I also want to speak to the incentives, particularly those of the Housing Championship Program. We see communities really reaching creative solutions when they have a toolbox that includes things like incentives to build housing. And we support the ability for a community to really chart that path forward and to build incentives as put forward in the Housing Championships. Communities have been using different financial tools to build affordable housing, and those outlined in the bill will really help as well. I'd be happy to answer any questions.
Questions? Seeing none.
Thank you.
New Hampshire Association of Realtors, Chris Norwood.
Thank you, Mr. Chair. Members of the committee, my name is Chris Norwood. I am the 2022 Chair of the New Hampshire Association of Realtors Public Policy Committee. Just briefly to expand upon some of the statistics that Senator Bradley said of the median sale price of over $400,000. 2 years ago, that was just around $300,000. But what I wanted to highlight is that this is not a pandemic issue. I can recall coming up here 4 or 5 years ago, maybe 6, but the median price was no more than $225 to $250. So we have been growing. This is not just a pandemic-related issue. To the senator's question relative to density, specifically for age-restricted housing, I can just speak with experience of one specific community that I've done business in that has a density bonus in one particular zone of 3 units per acre for age-restricted and 1 unit per acre for non-age restricted. And so when you have that imbalance inherent in the market, it makes it really challenging to create housing for anything other than age-restricted. And I'll just say in closing, having attended a number of these hearings over the years, plural, I think that it speaks volumes of the folks who have been testifying. You heard Senator Bradley read an op-ed from the BIA. I think 5-6 years ago, the business community was not as involved in housing as it currently is. I think that that speaks to the concept that we all see this as an economic issue as much as it is a housing issue. And the New Hampshire Association of Realtors would appreciate your support of Senate Bill 400. And I'll entertain any questions.
Seeing none, thank you very much.
Thank you, Mr. Chair.
Housing Action, New Hampshire, it looks like. Elisa?
Thank you, Mr. Chairman. I'll be brief. For the record, Alyssa Margolin. I serve as Director of Housing Action New Hampshire. We're a statewide coalition of 80 organizations and businesses united around affordable housing policy and ending homelessness in New Hampshire. Over the years, we've worked with many of you in this body to address the housing shortage. We also used to call it a shortage and feel that the word crisis is appropriate at this time. I do think that prior supporters and testifiers before you today have named some of the key themes about reasonableness, efficiencies, transparencies. I want to underscore that the policy experts who came together in 2019 viewed this indeed as a collaborative process, what was the proper role of the state and how to empower and enable communities who are ready to say yes in my backyard. Overall, this proposal is about carrots, a very New Hampshire approach to problem solving rather than sticks. And it's made every effort to balance interests wherever it can. In the spirit of that continued work of collaboration and partnership, I would just like to offer the opportunity to work with judiciary. Clearly, we want to have a proposal that works for the judiciary as well. So we would definitely be open to working on an amendment that addresses some of the concerns expressed today. And with that, I'll conclude and be happy to take any of your questions.
Questions? Seeing none, thank you very much. I don't know if there's another sheet in the back that completes what I've got. Is there anybody who did sign up after the sheet came up here? Seeing none, we'll close the public hearing. Did you want? Excuse me. Senator Rebecca Corcoran's, I thought it was the next bill or one of the other bills you want. She would like to speak.
I'm sorry.
And we're going to let her testify from her position.
Yeah, I didn't know when you wanted me to jump in, but thank you, and I'll be brief. I just want to echo everyone that's testified in support of this bill. In my role as a city councilor in 2019, I was part of drafting this bill, and I think it's a really technical set of recommendations that, as you've heard from everyone, really just enables our municipalities to move forward with this if their residents want through their normal processes. I'm proud to have worked on it because from my perspective, housing affects the future of our state in a variety of ways, but especially my generation, for people that are trying to come back or to build their lives here. It's important, and the same kind of housing that they seek, it's the same kind of housing that a lot of our retirees are looking for people to age in place. My mom turned 70 last year, and she's an example of someone that looked for a condo. It's the same kind of condo that a young family would look for. So I think this bill is a priority in terms of supporting that policy. And as Mr. Frost stated, we needed 20,000 units before the pandemic, and it's only gotten worse since then. So appreciate your support for this when it's time to vote. Thank you, Mr. Chair.
Okay, is there any questions of the senators? Thank you, none. Then we'll close the public hearing for real this time. Senator Perkins-Coie, would you work to resolve the issues that were brought up by the judicial system and get back to us with your recommendations on resolving those? I'd appreciate that.
Yes, I will, sir.
All right, and with that, we will start the public hearing on our next bill, Senate Bill 239. Oh, I'm going to give you this one, George. And hopefully Senator Guida will get us back on track here. He has an interest because I think the rest of the bills are his.
Thank you, Mr. Chairman, members of the committee. For the record, Bob Gaitis, representing the 27 communities in Senate District 2 and prime sponsor of Senate Bill 239 FN. I'd like to state for the record that I'm delighted at the presence of a clock, finally, that was not here yesterday but is here now to help us along in our deliberations. Senate Bill 239 is a derivative of the legislation that was passed and signed into law regarding a problem in one of the communities in my district. And in the course of that, resolving that issue, we had to pass a state law to require a community to comply with the requirements for performing an annual audit of their finances, all right? This was a subset, it was a precinct, as opposed to the community. And this exposed the fact that while there's a requirement to do so, there is no penalty or no incentive. This particular precinct had ignored willfully for decades the repeated telephonic, written, and emailed requests to perform the audit that's required by law. So what this bill does is it addresses that. It gives some strength to the Department of Revenue Administration, which drafted this language to address this issue for me. And it makes the recommendations, as you see, to ensure the performance of general municipal and county audits, okay? That's a requirement that they used to perform those audits years ago, but in the downsizing that happened in the early teens, 2014, 13, whatever, the entire audit staff from the DRA was removed, leaving them with no staff to perform audits and no statutory authority to require it. So this addresses that problem. It also adds not only municipalities but political subdivisions. That would be precincts, which was the genesis of this problem. And those political subdivisions would have to require, again. Interesting to note that the audit that was performed finally under the threat of significant financial penalties from DRA that we had to pass in statute to make this audit happen has disclosed numbers of significant irregularities in the financial management of that precinct. So this is a bill that essentially puts accountability to the public for those that are in a fiduciary position in our political subdivisions. It puts that in the hands of DRA with the technically competent personnel to evaluate these things and make recommendations to those communities. Without this, there's no need for a community to submit the audits as required by law and no penalty for their failure to do so. The bill is not stringent in the sense that it provides more than ample written notice and time for a community to at least contract for the performance of an audit and report that to the DRA so that we know that the process of following the laws requiring audits is in fact moving forward. With that, I will end my testimony and be happy to take any questions.
Questions of the senator? Seeing none, thank you very much.
Thank you, Mr. Chair.
There's only one other person who signed up to speak, actually two, NHDRA. We have both Mr. Gary and Ms. Lair. And while they're taking the podium, there are two other people who have signed in, not wishing to speak, both supporting the bill, Representative Norton Major and Representative Umberger.
Good afternoon. My name is Carolyn Lear. I'm the Assistant Commissioner at the Department of Revenue, and with me is James Gary. He is the Director of our Municipal and Property Division. We don't have a position on the proposed legislation, but wanted to acknowledge that we're probably uniquely equipped to answer any of your questions about the status of the law as it exists today and the scope of any non-compliance that does exist with the municipal audit requirement. So we're really here just to answer questions if you have them.
Questions? I think we're all set for right now.
Great. Thank you.
All right.
Credit for very short testimony.
Hey, we'll give you added bonus points at the next Assessing Standards Board.
Thank you, Senator.
All right. Is there anyone who signed up after I got the list? Oh, Margaret Burns, NHMA.
I didn't sign up. I apologize. I'm sort of accidentally here. Another member of our staff was going to speak, but I will speak. Good afternoon, Margaret Burns with NHMA. Senate Bill 239. We don't have a position on Senate Bill 239. Certainly performing an audit is already required by law, and it is a best practice anyways for a municipality. In fact, we've heard in recent days of municipalities that perhaps have not performed audits as they were supposed to, and what happens is that they cannot acquire bonds or TANs or other items like that that require an annual audit in order to be able to do an application. The only provision that we are opposed to would be the fine provision that is written into the bill. So not opposed to the concept and the intent of ensuring that municipalities fulfill their audits, but we are opposed to the fine and penalty that is in the second part of the bill. And I'm happy to try to take any questions.
Questions from the senators? Have you worked with Senator Gaida on that provision to see if you can come to an agreement?
I have not, but would be happy to.
Senator Gaida, you would also be happy to do that?
No, Mr. Chairman, I'd like to speak to that provision.
I'll allow you to come back up.
Thank you.
Thank you, Mr. Chairman. Again, Senator Bob Guida, District 2. The problem with taking the fines out is that it reverts us back to the very same process we had before, where there is no incentive or no prospective penalty for failure to comply. We can write letters and make phone calls and emails all day long, but at the end of the day, if a municipality or a political subdivision chooses not to comply with the law, with which your communities and mine do comply, there is no consequence. That's not an acceptable outcome for legislation. It, in fact, guts the entire purpose of the legislation, which is to hold municipalities and political subdivisions responsible for their failure to act under the law. Thank you, Mr. Chair.
Thank you, Senator. I didn't interpret that as the fines would completely go away, but that they had an objection to that section. I will contact my assistant to have a meeting with you and Ms. Burns in my office at your guys' convenience, and we'll talk about that issue and see if we can't come up with a consensus opinion that both can support. Any other questions from anyone? Seeing none, we'll close that public hearing. Yeah, you didn't even have to get up. And speaking of fines and penalties for various things, we're ready to start Senate Bill 405, and welcome the prime sponsor.
Thank you, Mr. Chairman. For the record, Bob Guida, Senate District 2, prime sponsor of Senate Bill 405, a fine bill, if you will.
Unintended.
Intended, yes, sir. So we have many laws in the state in which acts that are committed by individuals within the public sector are prohibited, but for which there is no significant repercussion if they're violated. Amongst those are some of the election laws that we have. For example, we had an incident, again, related to a community in my district, where the moderator ordered a sergeant of the police to remove lawfully placed yard signs of a candidate he opposed, and for which virtually no penalty was imposed. In which the moderator of a town during an election ordered a police officer to remove the lawfully placed signs of a candidate the moderator opposed. There's virtually no consequence. And we need to put teeth into our election laws, as is all the rage these days because of what the attention on election procedures and policies. But if there's not a disincentive for people to misbehave, then they will, as proved by this evidence. We know all the time that political signs get removed and stolen, and that essentially is not only just the removal of property, it's an infringement on the First Amendment rights of the candidate and the person from whose property the sign was removed. I believe we need to get serious about making very clear that we take the rights of candidates and of property owners very seriously. If you remove a sign, okay, or if you violate election laws, okay, the Attorney General will be knocking on your door with the ability to seek appropriate remedy from the offender. I'll take any questions.
Questions for the senator? Seeing none, thank you very much.
Thank you, Mr. Chairman.
And NHMA, Margaret, you're up next.
Thank you again, Mr. Chair. Margaret Burns with the New Hampshire Municipal Association, and we are here in support of Senate Bill 405, specifically the first section, which would create a new provision in 659 for intimidation of election officers. I have not heard of complaints or scenarios necessarily relative to this concern, but certainly providing a protection and a deterrent so that municipal officials and election officers can perform their duties and run the elections has good intent, and we would support it. That's all I have. Thank you.
Okay. Questions? Seeing none, thank you very much. Christina? Oh, it was blank, so I thought I'd call you anyway to find out. And you are in support. Is there anyone else who wishes to testify on this bill? Seeing none, we'll close the public hearing. And I'm going to give everybody 5 minutes before I start the next one, just in case they need anything. And Mr. Clemenceau, 34 pages at 10:34. I'm teasing. Apologies.
We're going this way to make sure we're avoiding the wire. As I say, we're coming on this side to avoid the wire. Yeah.
Bob.
And I'll try that again with the mic on. 418, Senator Guida.
Thank you, Mr. Chairman, members of the committee. For the record, Bob Guida, State Senator from District 2. Senate Bill 418 is a bill of extreme importance to the people and the election integrity of the state of New Hampshire. It's an attempt to close a loophole in our laws that enables anyone in the United States to come to New Hampshire, to vote in any election in our state, regardless of whether or not they're legally qualified to do so, and to have their votes count towards the election of our local, state, and national offices. This is a conundrum caused in large part by the constitutional requirement that all votes be counted on Election Day. In the absence of any means to ensure that a voter who votes without presenting the required qualification documents, but attests to their qualifications by affidavit, is in fact qualified to vote in our state. There is, however, no such same-day requirement for the certification of the results of our elections. And that is the genesis of this legislation. Our right to vote is not an unqualified right, as the legislature holds the constitutional authority to establish qualifications to lawfully vote here in New Hampshire. For years, we have failed to address the fact that votes cast by unqualified and therefore unlawful voters are included in our final vote counts and affect the outcome of our elections. The ballots of these unqualified voters actually nullify the votes of those who meet our legal voting requirements, and further, given the large number of very close election results over the years, as detailed in the findings section of this amendment, and I speak to Amendment 2022-0054S, which I request as a replace all amendment for the bill, as detailed in those findings, that shows that 230 unverified and unverifiable affidavit voters influenced the 2016 elections. We must give credence to the fact that the votes of unqualified voters who cast their ballots in New Hampshire do influence and can determine the outcome of our elections. Amendment 2022-0054S to Senate Bill 418 meets the constitutional requirement that all votes be counted on Election Day. It establishes a mechanism by which the Secretary of State can, after the votes are counted, but before the election results are certified, verify the qualifications of those voters who voted without proper photo ID or documentation of domicile at no cost to the voter. We do everything except go to their home and pick up their verification documentation. This measure will enable the true and accurate certification of the qualifications and returns of our elections, a constitutional function which has in recent memory been largely ceremonial. This bill is the result of many hours of discussion with recently retired Secretary of State Bill Gardner, and it earned his support. You will shortly hear testimony from newly sworn Secretary of State Dave Scanlan as the state's senior election official. I respectfully ask your support for Amendment 2022-0054S to Senate Bill 418FN. I do need to point out one additional change to the language that's required. That's on page 1, line 25. And that documentation was handed to you by the clerk prior to the start of this amendment hearing. Implementing these changes to our existing election laws will go a long way towards ensuring that every legitimate vote cast by a qualified New Hampshire voter is protected, that votes cast by those unqualified to do so are not certified and do not influence our final election outcomes, and that we're doing everything in our power to protect the integrity of the elections which determine the leadership and the direction of our communities, our state, and our nation. I thank you for your consideration, and I'm happy to take any questions.
Did we have copies of the amendments for anyone in the public that wants one? I can see a lot of heads shaking that they have copies, so.
No. I've got testimony for not amendments. I've only got testimony too. Well, that's the little amendment, but not the main.
I only have one extra.
I have one extra.
So, the senators are collecting up their extra copies. So to make sure that people who don't have them, if not,
I've got an extra one, I got one extra one here, so.
well, I don't know how many people have the
I got an
added
extra
language,
big one
but
and a number of extra little.
that's neither here nor there. All right, so how close are we to everybody that wants a copy having a copy? Is there anybody that doesn't have a copy that wants one? Good. Hey, we're doing well. Sorry for that delay, Senator, but I wanted to make sure.
I apologize for the amendments and.
Anybody that wants to, can at least read it while we're asking any questions that we have. Questions from the committee members? Senator Perkins Polka.
Thank you, Chair, and thank you, Senator Gatta, for being here to introduce this bill. So, in the original version of the bill, we targeted same-day registration or a voter that doesn't have a valid photo identification, but in the new amendment, as amended by your additional text today, you're trying to just target voters who don't have valid photo identification when they come to vote. Is that correct?
I'm not targeting anyone. I'm specifically saying that you can vote by affidavit, but you as a citizen of the state do have obligations, one of which is to provide documentation. And we give you that opportunity. We pay for you to send it back. We have 10 days. It's more than adequate time for the Secretary of State to require his functions or her functions to perform them. And so we don't target anyone. We just make all citizens equal because in the absence of this, every citizen in the state can vote by affidavit ballot and have no way of knowing, actually, that and citizens from outside the state can vote without any ability to certify the validity of their qualifications to vote. That is a wide open loophole. Anyone in the United States under current state law can come to this state and vote. And as you'll hear in later testimony, the number of those unverified voters, 230 in the 2016 election, that remain unverified and unverifiable today, given the close elections in statistics provided by the Secretary of State, is a concern. This doesn't target anyone. This makes all citizens equal. Thank you, Mr.
Follow-up, Chair.
Yes, ma'am.
Thank you, Senator Gatta. So just to be clear, the procedures under the bill, if someone at this point doesn't be adequate by the SOS, then the ballot they cast is then removed from the vote count within 10 days or within 14 days?
It will be removed from the vote count by the Secretary of State in time to certify, and also in sufficient time to allow for recounts that might be required by this. And they have time to do that. And the Secretary of State's office will testify to this here shortly.
Follow-up, Chair.
Yes, ma'am.
Okay, so under the procedures you're proposing, in page 2, lines 12 through 16 of your amendment, in order to remove those vote count totals, across our state from the various elections held on Election Day, the moderator is maintaining a non-public list of affidavit ballot numbers, the name of the affidavit ballot voter associated with each number, and the missing documents necessitated. So are you telling us that one of our most fundamental rules in elections, which is ballot privacy, will now be violated by the moderator maintaining a list of who voted and how?
No, what I'm telling you is we already have, as a moderator, I look at absentee ballots. Okay? I don't care how they vote or who they vote, okay, but I know who they are. The same process here. This uses established law and the processes therein, okay? We don't provide any further power to moderators or any less. We just use the powers already existing in the law to enable them to provide the information to the Secretary of State, to reduce the vote counts appropriately for ballots whose votes were not qualified and therefore should not be certified.
Follow-up, Chair?
Yes, ma'am.
In 2016, we saw close to 100,000 same-day registrations. So even though you're saying it would be an expansion of the same powers that exist under the law, the effect would be that, potentially 100,000, if not more, voters could have their votes tabulated on lists across our state. Is that correct?
No, we're not going after same-day registrants. We're going after unqualified. So if you have to sign an affidavit because you have not produced the documentation that certifies you to be qualified to vote, then this process would go in. If a same-day registrant shows up with the required photo ID and domicile proof, there's no action taken because they've met the qualifications.
Thank you. We've heard you and others defend the integrity of our elections, and we've used that to make sure that New Hampshire maintains its position as first in the nation with our first in the nation primary. Are you saying that the results of the first in the nation primary could be provisional for up to a 14-day period following our elections?
That's a possibility. That's a possibility. However, I will state for the record, okay, the integrity of our elections is paramount. And the primacy of a first in the nation primary with an inaccurate vote total that possibly, as you'll hear in later testimony, could influence the outcome of national elections is more important to me, okay, than the commercial appeal of a first in the nation. We need to do it first. We also need to do it best. That's what New Hampshire is known for.
Follow-up, Chair.
Yes, ma'am.
Have you thought of the logistical challenges of this? So, depending on how many people need to fill out this affidavit, the follow-up packet needs to be processed within a 10-day period. Depending on how many hours that would take, it could even require additional staff. Are we relying on cities and towns to hire that additional staff?
Cities and towns will not be required to hire any additional staff. Office that will be addressed, I think, by Secretary Scanlan here shortly. The work is done. The Secretary of State designs, produces, and pays for the affidavit ballot package. Okay, all it's done right now is no more than is done already by the moderator to mark and number the ballot. Okay, the letter and the envelope go home with the voter, and the voter then sends back the documentation that's required, that's shown as not being presented but necessary in the letter, the verification letter. The work is done by the Secretary of State, not by the local clerks.
Follow-up, Chair.
Yes, ma'am.
In one version of the bill, you have anyone who doesn't return this packet or who's not able to be verified within that 10-day period is being referred to the Attorney General for further investigation. So someone who forgets their driver's license but goes to exercise their civic duty runs the risk of being referred to the Attorney General simply for forgetting that?
That happens today under current law. Okay, if you sign an affidavit ballot, they are forwarded to the Secretary of State. Secretary of State then performs an investigation of sorts. People that don't meet the requirements for whom they can't get documentation are referred to the Attorney General for prosecution. And that has happened a number of times in the past. Unfortunately, that problem is minor. The real problem is that unqualified votes are cast in the election and certified as valid and can impact the outcome of the election.
No further questions, Chair.
Perkins Quokka started the question. If I'm in a very small town, you said that the moderator already knows who votes by absentee ballot, but if my vote is provisional and I'm the only provisional ballot and it's disqualified after the fact, the vote totals are going to reflect how I voted. So therefore, how does this not violate my privacy in that case?
No one's going to know how you voted.
Well, they will if the election results change. If the election were decided by one vote, and 10 days later, if I haven't provided this, then you're going to subtract one from that vote total. So that would be my one vote if I were that individual in a town. So
one could assert that because you voted unqualified and therefore illegally, okay, you're going to be prosecuted by the Attorney General, and your right to privacy doesn't exist. You have violated the law.
may I ask a second question, different topic?
Yes, ma'am.
as I read this amendment makes no provision for, and let me give you an example because this happens frequently. So I represent 5 wards in the city of Manchester. 3 of them are tangentially inner city. So they're people that, live in tenements, apartments. In addition to changing the ward lines, it's not unusual for people to move from various apartments periodically, looking for either better rates or more affordable housing. It's conceivable for somebody who is a registered voter in Ward 7 to move across the street and be in Ward 5. They would then appear at the polling place, not necessarily prepared to provide proof of identity. They're already a registered voter, they just didn't realize that they're now in another ward. So they have to be processed as a new voter. Is there any exception for people that are already registered voters? Because the people working at the polling place in Ward 5 are not going to know other than the representation of the individual. But that's going to make a lot of work, particularly in our cities, for people that are trying to process all of these claims. Is there any provision for someone, if it's shown that they are actually in fact changing registration within the state?
They can sign, as they do now, an affidavit that says, what I show on my driver's license for an address is not my domicile. That's required under current law, so we're not creating anything new. Further, I would assert that the last thing I'm worried about is the work effort of the election officials as compared to the need for the sanctity of our elections and their integrity.
But Senator, I don't think you understood my question. I understand that the voter is still going to be able to vote. My question is, do we make any exception once that information is taken? Do we do any kind of search to see if they were already on a checklist in another New Hampshire community and then put that aside because
At this time, I don't think that's possible, but I do think that there's a system that is in work to enable that to be put into place. But at this time, we have to do that anyway. So if you change wards or you change towns or districts, you're still going to be required by this law unless you can produce your rent contract or your utility bill and a photo ID, you're going to be required to vote by affidavit ballot. That's required today.
Okay.
Questions from anyone else? All right, I'll ask a couple of expanding questions for, there's a provision in state law right now, as I understand, is that voters who comes without an ID can be verified by the moderator, by the supervisor of the checklist, or the ward clerk. Has any of that changed?
No, not according to the amendment. It might have changed in the original bill. We talked with the Secretary of State's office and a number of other people. So the answer is that will not change.
After the election, the city clerks, in the case that the senator brought up, would be tasked with entering the people who voted into the database. And as far as I know, that New Hampshire voter database will pop up the name of someone who was registered in a different ward. In fact, that's a category on the thing. Would that be identified at that time?
Is that a question?
Yes.
Okay.
Will it be identified when they go to put that information in, to the best of your knowledge?
I can't answer that question.
All right, we'll have the Secretary of State answer that later. Any additional questions? Okay, thank you very much.
Thank you, Mr. Chair, members of the committee.
Secretary, I would normally wait for you for a couple of people at least. You can testify now, or you can wait until after the League of Women Voters and the ACLU, whichever you choose.
If you don't mind, Mr. Chair, I'll testify now.
Absolutely.
Thank you, Mr. Chairman and members of the committee. I'm David Scanlan, Secretary of State, here to support this bill. I want to explain the reason why. I believe that the largest problem that we have facing our elections today is a pretty dramatic erosion in voter confidence. It's happening here in New Hampshire, and it's certainly happening nationwide. A lot of it's because of national rhetoric. A lot of it's because of unique situations that happened in New Hampshire in the last election. But the end result is that there are voters that are just not feeling like the votes are being accurately counted. And there's a lot of suspicion out there in terms of the practices. And there's certainly steps that we can help to alleviate some of those concerns with the way we manage elections. But we have to address a much larger fundamental issue, and that is that not only should we make it as easy as possible for all qualified voters, National Voter Registration Act, and that act, along with the Help America Vote Act, has a provision in there, prove their qualification, or if there's some question about it, vote on a provisional ballot. And that ballot gets counted at some point after the election if the information on that voter can be verified. What's being proposed in this bill is, I'll call it a New Hampshire version of that, a provisional ballot that is actually counted on the day of the election with a provision that if a voter can't prove their qualifications or verify their qualifications, that the vote is then subtracted after the fact. So in one respect, we are no different than the way most other states treat the subject. But in a true New Hampshire fashion, the vote would be counted on the day of the election, thereby complying with our state constitution, that all votes be counted on the day of the election. I think that there are some questions that were raised by Senator Soucy and Senator Perkins-Coie that are fairly taken before a court. And, you know, I know that it is a tool that the legislature has for the Senate to, you know, determine what those constitutional questions might be, you know, whether in fact a vote can be counted or removed after the fact, after it's already been counted. You know, lay the bill on the table and send those questions to the Supreme Court to see what their reaction is to that. But I believe that we really need to have this discussion, and that a bill like this should not be simply discarded on its face or approved on its face, but you know, we have that debate that is going to help reinstill the confidence that voters have had in New Hampshire elections for a long, long time. And with that, I would be happy to answer any questions.
Questions from the senators? Senator Perkins-Coie.
Thank you, Chair, and thank you, Secretary Scanlan, for being here. You know, we've heard you, we've heard former Secretary of State Gardner, we've heard the governor, we've heard members of the committee talk about the integrity of New Hampshire elections. We saw that, you know, even when we needed to audit, or we did that job, and, you know, the integrity of the election was upheld. So, you know, bills like this, there's some reason to be concerned about our elections. In 2016, by the Attorney General was able to prove, it doesn't mean those 66 people even committed fraud, but that, you know, they just weren't able to establish that identity. So, you know, there isn't a problem here, in my opinion, and so I wonder, you know, why lend your support to something that could put our elections and the results that we receive the same day in such jeopardy instead?
That's a really good question, and I will be the first to say that New Hampshire elections are sound. I have complete confidence in them. I know that the local election officials, 6,000 of them on any given election day, statewide, do a tremendous job. They're all dedicated, and you know, they undertake this volunteerism with the right attitude. Despite that, however, you know, we have leaders in both political parties that are saying things that shake that confidence and instill doubt, even though, from my perspective, you know, things are running smoothly. But we have to address the perceptions, and we have to address, you know, the concerns that voters have, and really the best way to do it is to show them. And I think that this is a multifaceted task on our part. One is to create as much transparency in the process as we can. Number two is we do additional training for local election officials so that the unfortunate errors that take place, and they're human errors, I mean, they're intentional errors, but if we can limit those to the extent possible, that's beneficial. And then the one area where we've been taking it for granted and have not spent a lot of effort addressing it is the education of the average voter out there. I was in a couple of committee hearings on the House side today, and I heard individuals testifying on the legislation, and it was very clear to me that they were just uninformed with major portions of the election process, and they were making assumptions that just weren't based in fact, but it's what they believe. And so we have to spend a lot more time addressing those situations as well.
Follow-up, Chair.
Yes, ma'am.
You were asked a similar question in the last 24 hours, but I mean, why not, instead of spending our time and effort on legislation like this?
I'm sorry, I'm not hearing you.
Sorry. Why not, instead of spending our time on legislation like this, why not run an education campaign out of the Secretary of State's office or take other action that, increases education and confidence in our election instead of a bill like this, which jeopardizes people's ability to vote?
New Hampshire thing, but the other side of that is that you have a major segment of the population that wants to make sure that the people that are participating in that process are qualified, and it is not unreasonable, it is not suppression to say or implement things that where people simply demonstrate the qualifications that they have. It's not meant to be burdensome, but there should be some effort to show that I'm qualified and I'm willing to let my fellow voters know that I'm qualified.
Follow-up, Chair.
Senator.
Yeah, just last question. Do you not have concerns over the privacy implications of this bill? I mean, I am alarmed by the idea of there being a list maintained with our ballot numbers, we saw, and maybe Senator Guida is not targeting same-day registrations anymore. It's a little unclear since we're receiving all these last-minute documents from him, but we saw almost 100,000 people same-day register in 2016. So at this moment, where I don't have an official amendment, that changes this target from same-day registration, we have to assume this could affect up to 100,000 people in the next election. That's a lot of people to maintain their votes and their records, and it affects a lot of elections across the state. That's concerning to me, and I was hoping you could just share some thoughts on that.
Certainly that's a concern of mine, and I'm not sure that was clear when I started my remarks, but I support this bill with the amendments that Senator Guida offered. I think the introduced version did have some larger problems with the privacy issue. The way this language is designed is to mirror the way a challenged absentee ballot is treated, and so there is some precedent for the way it's done. The moderator is responsible for keeping track of that information. I believe Senator Guida mentioned that the moderator is also responsible for processing the absentee ballots, and there's an opportunity there for that person to see voters' marks on the ballot, even though the state law says that the moderator shouldn't look and just put the ballot in a pile. But that's why we elect moderators locally, is because we trust those individuals based on their integrity and their reputation to run a clean, fair election and keep certain things private. There are other aspects of election where it's difficult to keep a voter's identity private too. If you have one UOCAVA voter in town and they send their paper ballot in, it's going to look different than the others. And the same is true with accessible voting, although we've come a long way in terms of standardizing that process now. But individuals with print disabilities can print off a ballot on their home printer, mark it, and send it back. I mean, there's another example where privacy may be compromised a little bit. There is going to be some of that in any given election. I would not want to see it widespread, but I do share that concern.
Yes, ma'am.
I understand this is nice from your absentee ballot is challenged, but isn't an absentee ballot challenge before the contents of the ballot or sort of the votes cast are known?
I'm sorry, I didn't hear you.
Let's turn on my microphone.
The question has to do with absentee ballot in the order of when the absentee ballot
It's challenged.
is challenged
Yeah.
and when the content of that ballot would be available to somebody.
Right, so my understanding of the absentee ballot challenge is that if the moderator finds that the challenge is well-grounded, the moderator will write on the back of the absentee ballot, challenge ballot number 1, in sequential as those challenges are made. And granted, I don't believe there's many of those, if any, in any given election, but that's the process. And then the moderator, I believe, writes the same challenge voter number on the envelope that the absentee ballot was contained in.
Senator Sissy.
Could I just follow up on that? But you said the challenge by the challenge is written on the envelope by the moderator, but that means that the ballot hasn't been removed. I think what Senator Perkins Coco was trying to get at is, in those cases, the challenge occurs before the removal of the ballot, so you're less likely to have somebody see the ballot, whereas in this case, the ballot will have been removed and will be part of the count. So I think there's a distinction.
I'm actually referring to a absentee ballot that has been challenged where, and I really ought to have the statute book in front of me, but where the moderator has made a determination that the ballot should still get counted. He or she would write challenge ballot number on the back of the ballot and then proceed to process it. I'll find that reference and make sure you get it.
May I ask one additional question?
Absolutely, Senator.
My question is regarding the UCAVA ballots. You mentioned that they are distinct, they look different. Under this scenario, though, wouldn't it take us nearly 14 days to prepare the UCAVA ballots? So in a case where we have a primary, because we're late, we're in September, we have to get those UCAVA ballots out to comply with federal law. If there were a discrepancy, so we were off, but we had a primary for one of the congressional seats, what would happen? How would we be able to comply with federal law in that case and get those UCAVA ballots? Because for federal elections, they're certainly able to vote.
That part of the bill probably needs a little bit of work. I think the standard time between the primary and having to get the UCAVA ballots out is about 10 days.
But you do agree, this would be
there's a
14 days
conflict,
to
yeah,
verify, so we could run afoul
There's a conflict in there, yes.
very easily in disenfranchised military voters. Okay, thank you.
Senator Bertzel.
Thank you, Secretary, for coming in. Yesterday, I heard that this fall's elections may be illegitimate. Do you have any concerns about the legitimacy of this fall's elections in New Hampshire?
No, absolutely not.
Thank you.
Seeing no other questions, I have one request of you. To introduce your new member of your staff,
Thank you for doing.
the Honorable Ms. Lovejoy.
Yeah, so, I have been on this job now for a little over a week, and it seems like it's well over a month. But things are going smoothly. I've been putting a team in place that is bipartisan. I'm selecting members from both political parties, and I'm happy to introduce former Representative Patty Lovejoy. For those of you who do not know her, Patty has worked with us for years on recounts, does an outstanding job. She has a background in accounting and served on the House Finance Committee for at least a couple of terms, if not more. And she has jumped in with both feet, and she's in the position of Senior Deputy Secretary of State, which is part-time, but it's the role that Bob Ambrose was in while he was here with Bill Gardner.
Welcome.
Thank you.
Thank you. League of Women Voters, Liz.
Not big enough. Thank you, Senator. Thank you, committee, for this opportunity to speak. I do have written testimony prepared, and I will give that to the clerk in a minute. But two things came up in what I've heard so far today about this bill that I would like to address. I'm sorry, I didn't introduce myself formally. Liz Tentarelli, I'm president and partisan League of Women Voters of New Hampshire. And we oppose this bill. What I heard today is from two people is that there is a lack of confidence in our elections. I would challenge this committee and even the sponsors to say, how do we foster confidence in an election when some voters are given ballots of a different color, have little serial strips attached to their votes, are sent away with a packet with instructions that may be very confusing for them to fill out, which they may simply stick in their cars or in their pockets and never get to because they think they've already voted. I don't see how any of that is going to foster confidence in our elections. In 2017, we had Senate Bill 3, which the League challenged in court. And while that court case was going on, the bill was stayed. So Senate Bill 3 operated in only one election from the time it was passed. The reason given for Senate Bill 3 was to avert voter fraud. Do we have voter fraud since 2017 in any numbers much bigger than there ever were? I don't think so. We have some having homes in two towns entitled him to 2 votes. This is not the kind of voter fraud that we're worried about if this is all that's happening. I appreciate what Senator Guida said about the closeness of some elections. And we do find that out, and we want to avoid that, of course, that fraudulent votes are cast. But they are so rare that I would ask whether the complications of this bill for both the voters and for the election officials is worth the effort when it may very well discourage voters. As you know, the League of Women Voters works very hard to educate voters about what they need to do in order to register and in order to cast a ballot. The more complicated that gets, the harder it is for us to explain it in terms that everyone would understand, and the harder it is for voters to feel they can do it. I've seen people look at a description of what you need to do, what you need to do to vote and say, I don't get it. And I suspect they never vote. So that's very different from what I wrote to you, but I think I covered what I wanted to, and I will give you written testimony, but I'm happy to take questions if you have any.
Questions from the senators? Seeing none, thank you very much, Liz.
Thank you.
And we'll go to ACLU New Hampshire. Henry.
Thank you, Mr. Chairman and members of the Senate Election Law and Municipal Affairs Committee. My name is Henry Clementowicz. I'm a senior staff attorney at the ACLU of New Hampshire. We're a nonpartisan, nonprofit organization which has been working to protect civil liberties throughout the state for over 50 years. I also have in one capacity or another served as counsel in the last 2 voting rights cases to go to the New Hampshire Supreme Court. That was League of Women Voters of New Hampshire versus Gardner and Caroline Casey versus Gardner.
I think that this bill, which we urge you to oppose, sends exactly the direction. Governor Sununu said, "Here in New Hampshire, our elections are secure, accurate, and reliable. There's no question about it." With that being the case, what are we doing passing laws that would potentially throw out thousands of votes? In my view, this legislation could violate the Constitution in at least 3 ways, and I'm happy to go through them. As Secretary of State Scanlan testified, it's been a long-standing position of the Secretary of State and Attorney General's office that the New Hampshire Constitution requires that all ballots be counted in the day that they were cast. That's why, for example, that office has historically opposed, and one of the reasons why we don't have a period for absentee ballots to be cured or after they've been cast, because those ballots need to be counted on the day that they were cast, and that's what the Constitution requires. Establishing absent affidavit ballots could cause tens of thousands, hundreds of thousands, depending on what category of people have to vote by affidavit ballot, to be counted and then possibly subtracted 10 days later. This could lead to, as a previous speaker suggested, a situation in which our presidential primary, the results are tabulated for one candidate, Nevada happens, they vote, and then 3 days later we find out that, in fact, somebody else won the New Hampshire presidential primary. In addition, this would significantly change the way that New Hampshire voters are able to vote if they don't have any of the required documents. So, for example, it's unclear to me under the various versions of the bill under consideration whether one would vote by affidavit ballot, for example, if one did not have proof of citizenship. But if that were the case, a person would need to every single person who's registering to vote would need to produce either a birth certificate, naturalization papers, or a passport. These can be expensive and time-consuming to get. For example, a passport book costs $110, and routine service takes 10 to 12 weeks. The time to acquire a birth certificate can vary depending on the municipality of birth, but in New Hampshire, for example, it costs $15, whereas a birth record for an American born abroad requires a notarized request to the State Department, and I imagine takes a significant period of time, probably well beyond the 10-day cure period that a person would have to produce documents to prove citizenship. And perhaps that's why in 2020, the 10th Circuit Court of Appeals in a case called Fish versus Schwab struck down as unconstitutional a documentary proof of citizenship requirement, which required everyone in Kansas who wanted to vote to produce documentary proof of citizenship. And the court found that the state's interests were, quote, insufficiently weighty to justify the limitations on the right to vote imposed by the DPOC requirement. So the same would be true for proof of domicile requirements. So left out of the conversation to date are people who validly live in New Hampshire, have a domicile in New Hampshire, but don't have any documentation to prove that. So that could be somebody who's couch surfing or subleasing. It could be a person who's experiencing homelessness, who's entitled to vote, but won't have a scrap of paper with their address on it anywhere that they can produce. Under this bill, if it became law, all those people would be erroneously deprived of the right to vote. We know that in 2020, 814,499 voters cast a ballot. That was an increase over the 7,550,000 people who voted in the presidential election in 2016. Nonetheless, the legislative findings identify 10 cases of illegal ballots out of those 700,000 plus ballots that were cast. And moreover, none of those cases, we don't know if any of those cases would have been deterred by this bill. And that's a crucial point, is we have no idea if any of those people who were found to have committed double voting or voting fraud used an affidavit. Maybe they had a fake document, maybe they voted under someone else's name, right? We don't know that this bill would do anything to actually solve those 10 cases of voter fraud, but we do know that it would impose significant burdens on many people. In addition, there's, I think, a real possibility that this bill could put New Hampshire's exemption from the motor voter law at risk. As this committee knows, New Hampshire is exempt from the NVRA because it has maintained a continuous law since 1993, which allows all same-day registrants to vote. It would be up to the Department of Justice to determine whether this bill, if it were enacted, significantly changes the law around same-day voter registration or prevents some people who register on election day from voting. And of course, once we lose our same-day registration exemption from the NVRA, we can't get it back. This proposal would destroy ballot secrecy, as some have said. Under this provision, every single moderator would create a list identifying by name the affidavit ballot of every single person who votes with an affidavit ballot. I just want to tell you what the U.S. Supreme Court has said about ballot secrecy. In a case from 1992, they said, quote, all 50 states, together with numerous other Western democracies, settled on the same solution, a secret ballot secured in part by a restricted zone around the voting compartments. We find that this widespread and time-tested consensus demonstrates that some restricted zone is necessary in order to serve the state's compelling interest in preventing voter intimidation and election fraud. So we have voter ballot secrecy for a reason. It's not just because people are entitled to be able to cast their vote in secret because it's such a matter of consciousness, but it's also to prevent voter intimidation. It's to prevent someone from saying, you know, you vote this way or else, or I'll give you money if you vote a particular way. What we would be doing under this statute is literally creating a list of every person who votes by absentee ballot, along with a reference that can be used to determine how they voted. And that's different from how the absentee ballot process works. In the normal processing of absentee ballots, of course, the envelopes are processed and the affidavits are reviewed before the ballots are reviewed. Secretary of State Scanlan suggested that it may be a different procedure for those who are challenged affidavit absentee ballot voters, but we know that that's a significantly smaller number. And just to give you an idea of what we're talking about, tens of thousands of people use same-day voter registration every election. Whether all of those people would have to vote by affidavit ballot, I think is unclear depending on the text that we're looking at. But certainly 637 people used following the 2020 election the qualified voter affidavit when registering without voter ID, and 816 people used the qualified voter affidavit when registering without proof of citizenship. So potentially 1,400 people's ballots could be easily identified by a moderator. Under the initial version, as I understand it, those people would be given a different color ballot, a sort of scarlet letter, if you will, making it noticeable to the entire community that they're voting by affidavit ballot and further increasing the risk of erosion to ballot secrecy. And then the last thing that I just want to talk about is the possibility that this could cost the state millions of dollars in legal fees. Following 2017's enactment of Senate Bill 3, which was also passed with the support of the Secretary of State's office, 3 Superior Court judges struck down parts of the law before the New Hampshire Supreme Court ruled it unconstitutional in its entirety in 2021. Following that determination, the state paid $3,350,000 to the lawyers suing the state, as well as over $800,000 to outside counsel that the state had hired to help defend the law. So that was in excess of $4 million that the state spent just to pay lawyers to fight over a law that was enforced for one election and ultimately deemed unconstitutional. I think the same problems exist with this bill. I think that the packeting being turned out to people, the packets given to people when they vote by affidavit ballot would cause the same sort of problems of confusion in lines that the court found so problematic in the League of Women Voters of New Hampshire versus Secretary of State lawsuit. And I just point out that like all election materials would be printed only in English, and especially incomprehensible for people who are entitled to vote who may not speak English or read English. And so in conclusion, I'll just say that the goal of SB 418 seems to be to impose new unnecessary burdens on voters. This flies in the face of Governor Sununu's statements about our elections being safe and reliable. There's no need for this bill, and it risks upending our electoral system by injecting confusion, delay, erroneous disenfranchisement, and cost for no obvious benefit.
Questions from the senators? Senator Susi.
Just one. I wanted to go back to one of the issues
process and how this would work. If someone is homeless, they may use the homeless shelter if in fact they're staying there as an address, but would have no way to prove that that's where they're staying. So I'm wondering what in that instance, because they may or may not have access, as you said, to certain other documents like a birth certificate,
Right.
passport, or anything, and may not have the money to be able to obtain them.
Right, I think that person would be disenfranchised after 10 days when they're unable to return proof of documentation of domicile to the Secretary of State's office. And those are for the people who are experiencing homelessness that are lucky enough to stay in a shelter. They may be able to get documentation, but those who don't, who are camping, who are living in a park, there won't be any documentation to be had at all.
Well, but they are entitled to vote because they are New Hampshire residents, and we've established in statute a process to allow people who are homeless at the time of elections to vote.
Absolutely, and that's consistent with the New Hampshire Constitution's requirement that all inhabitants of New Hampshire are entitled to vote.
Thank you.
Seeing there's others, I'll ask a few. What are the provisions in state law for supervisor checklist to accept a signed letter from a landlord or an operator of a shelter to prove domicile, identity, and other things?
So the supervisors of there's a list of documents that are enumerated in statute to be used to prove the four qualifications: age, identity, citizenship, and domicile. A signed letter from a landlord probably would qualify, but some people who are couch surfing or who are subletting in violation of a lease may not have access to that letter. And actually, Senator Gray, I did, this just reminds me, I wanted to respond to an earlier question you had asked about the verification of a voter's identity by an election official. And looking at the second to last line on page 4 of Amendment 2022-0054S, that would actually repeal RSA 659-13 Roman 2B relative to the verification of a voter's identity by election officials. So
I'm sure that Senator Gaida has just taken note of that. So a person who is couch sitting could get a letter from the owner or renter of that property. I believe that that's still consistent with what you quoted before. And I don't understand why they wouldn't have access, because that would be their access.
So I'd have to look at the statute. I think that it does talk about, and it's been a little while since I looked specifically at the statute, but I think it does talk about a lease or a note from the landlord. I'm not sure that it explicitly allows a note from sort of a sublessor, like from a lessor to a sublessor, to count. It also is not clear that in all situations you could have a situation in which a tenant's relationship with their landlord is fraught, right? We know this happens for a number of reasons. People get delinquent on their rent, or there's issues with the heating in their house, and people are not talking to each other beyond just dropping off the check. There's no requirement in the statute that a landlord has to furnish such a letter for a tenant who wants one. And so, while for many people that may be an option, it may not be for some people, and those people would still be entitled to vote but wouldn't have a way to do so under this bill.
Senator Perkins-Coker.
Thank you, Chair. And Henry, you mentioned that this bill has the potential to qualify or disqualify us from our waiver under the National Right to Vote Act. Could you just talk a little bit about what the consequences would be if we were then subject to that authority again?
Sure. So New Hampshire's same-day voter registration exemption from the National Voter Registration Act is what exempts us from the requirement that people have to be able to register to vote at DMV or other similar state agencies that provide resources directly to the public. So in the, I think, 46 states that are subject to the NVRA, you can register to vote at DMV. That's not the case in New Hampshire. People in New Hampshire can only register to vote either at a meeting of the supervisors of the checklist, at the polling place before those supervisors, or sort of indirectly at town hall by meeting with the town clerk. And so If we were to lose our exemption, New Hampshire would have to create an entire new system to allow people to register to vote at DMV and other state agencies, which I assume would cost millions of dollars.
I will defer any more of my questions to later since we are going quite late. So thank you for your testimony.
Thank you.
And we'll call the next is Christina Guilford.
Hello, and thank you for listening to what I have to say. I do want to apologize because I just saw...
For the record, introduce.
I'm sorry, Christina Guilford, Derry Town and School Moderator. I do want to apologize because I only got the amendment when it was just handed to me. The amendment did answer a lot of the concerns that I had, but it does bring up a couple of others. So, as moderator, I kind of have a little bit of an issue of creating a list with people's names. And I know it's not subject to disclosure under 91A or any other means whatsoever, but I just, it makes me nervous making a list like that. I also have a huge issue on the 11th, it's on page 2, sections 23 to 30. And they're sitting here talking about basically reopening the boxes to pull out these ballots. Such a big deal is made about election integrity and security, and we take, at least in Derry, great care to tape the ballots and do all those things, and those seals are not to be broken. The only time they're broken is if they go for a recount up to the Secretary of State's office. And all of a sudden, we're going to be opening and basically leafing through, for example, November 2020, 18,000 ballots in Derry, trying to find the ballots with these numbers. And that's a double-sided ballot, so it's not like you can even write it kind of large on one side or whatever. It's going to need to be very small in a corner. That's going to take a lot of time. And it says with, using methods of counting and observation, I understand that. It just makes me, again, very nervous to be reopening all these boxes all over again. And then I do feel that there are a lot of people who arrive at the polling place. I know because I've been working elections for a very long time. In fact, we just had a special election in December, and I had a woman who came in with a cane. It was December, it was cold, it was late. And she got all the way in and completely realized that she had forgotten her ID. And so she had to fill out, the challenged voter affidavit, take her picture, sign the form, and she was easily able to vote. She's already on the checklist. And now it seems like an innocent mistake now is going to cause a specialty ballot. And then they're going to have to, go get a copy of their license and send it in. We also have some voters in Derry. I know that they're old. I have one gentleman, he's almost always within the first 5 voters through the door. He comes in with his son. He's in his late 90s. He no longer knows where his ID is, and he doesn't have one. Every election, I remind him that there's a free ID available from the state for voting purposes, and his answer to me is just take my picture and I'll sign the form. And how is he then afterwards going to be able to fix that? But he's been a Derry resident for 50 some odd years, and he's been voting in Derry for 50 some odd years. At this point, I know him, personally at this point, after working elections for many, many years and seeing him around town and his family around town. But the provision to identify him is removed here. So I'm concerned that this is going to discourage legitimate voters, and people are going to bring in, I don't know, the ones who really want to fraudulently vote are just going to probably come in with fake documents and vote that way. I don't know. I'm concerned that we're just going to turn away legitimate voters.
Okay, thank you. Questions from Senator Perkins-Coker?
Thank you, Chair. So in your opinion, Christina, and thank you for being here today, we heard the prime sponsor say that this bill would not cost towns and cities a dime, but it sounds like, just anticipating what the workload would be, this would create additional time and energy that needs to be put into elections.
Well, I have no problem putting more time and energy in for election integrity, myself personally. It's not like moderators make a lot of money anyway. That's not a big deal. But I can tell you that if I'm going to have to reopen 65 boxes of ballots, because that's how many we had from the November 2020 election, that's going to involve myself, the town clerk, other election officials. I'm going to need some poll workers. There is going to be an expense, definitely, because I have to hunt down those ballots, unless we're going to make them put a ballot in a separate box. I'm not sure if there's a solution here. I'm just trying to understand the logistics of it. I mean, the original bill had supervisors of the checklists handing out ballots, so I was glad to see that that's been fixed, but that's more that my issue there is just how do we actually execute this in a normal manner.
Additional questions?
Thank you.
Seeing none, thank you very much. Dr. Strang.
Good afternoon, Senators. My name is Dr. David Strang, and I am speaking in support of this amendment to this legislation that seeks to improve New Hampshire election law and reduce the concern over same-day registration currently shared by many of the citizens of the state. Election integrity is an ideal that we all, regardless of political party, should seek, should strive for with the utmost zeal. The thought that someone occupying an office did not, in fact, earn the right to do so should be repugnant to us all. For nearly a half century in our state, almost one election per year has been decided by just one vote or resulted in a tie, often to be decided by the flip of a coin or some other means of chance. In the 2016 general election, the last for which we have final data, 230 voters cast ballots, yet could not have their identities or their residence verified by the Attorney General's office. Does that level of uncertainty concern you? It certainly would have New Hampshire politicians Lewis Wyman and John Durkin, whose 1974 U.S. Senate matchup was decided by just 2 votes, the closest in not just New Hampshire history, but U.S. history. This bill would not add significant workload to the election officials processing these voters on the day of the election, as all they would have to do is circle the documentation missing on a piece of paper and hand that letter in an envelope to the voter. At the end of the day, they would send their copy of that letter to the Secretary of State. Done. Yes, more work would need to be done by the Secretary of State's office, but Secretary of State Scanlan has already gone on the record stating that this could be managed quickly so as not to unduly delay recounts and certification of the vote. The beauty of Senate Bill 418 is that it builds on existing New Hampshire law that has been in place for many, many years. Already ensconced in RSA 654 and 659 is the requirement to vote by challenge voter affidavit if you attempt to vote without a photo ID, as well as by qualified voter affidavit if you attempt to register without a photo ID, and by domicile affidavit if you register without the documentation to prove that you actually reside and have a domicile in that town, city, ward, or district. This bill strengthens those existing RSAs. It also reinforces the legislature's
constitutional authority to establish voting requirements with now the ability to enforce those requirements. Gone will be the time when we had to count and certify all votes, only to find out months later that we potentially had been duped into certifying illegitimate votes, with no means to remove that office holder who was improperly installed. I strongly urge all members of this committee to support the amendment to this bill, as it will provide yet one more means to ensure that New Hampshire's elections are as fair as possible. Before I conclude, I'd like to just address a few comments that were made by previous individuals who offered testimony. The woman from the League of Women Voters said that we should simply trust all people who show up to cast a ballot. I'm reminded of Ronald Reagan's wisdom when dealing with the Soviet Union: trust but verify. She also insinuated that we would be discouraging voters from actually voting. We're not discouraging anything. We're simply giving them yet a third and final opportunity to show that they had a legitimate right to cast a ballot. People should be registering before the election. But if you want to wait until the last minute, you still have to come in with proper identification proving who you are and that you actually reside in that town, city, ward, or district. And if you don't do it the day of the election, we're giving you one final chance to do that before the vote is certified. If you want to take a flight from Logan Airport and you show up without your passport, try boarding that flight by claiming that you're being discriminated against. If you are on a flight from Logan and there were 5 people whose identity was not known, wouldn't that make you nervous? Someone also mentioned that this might create a violation of privacy, and I would assert that this is already happening in our state. Dixville Notch has, what, 5 voters? And they love to announce their voting results at midnight. If all 5 voters voted for the same candidate, there is no right to privacy. And I guarantee you, even if the vote is 4-1 or 3-2, the people in that town know how they voted. But if someone seeks to deceive by voting illegitimately, I assert there is no right to privacy. Currently in New Hampshire RSA, when it comes to prescription violation, and this is something I know something about as an emergency physician, if someone comes in and attempts to deceive me in an attempt to induce a prescription for a controlled substance like oxycodone, there is no right to privacy. It's right in RSA 318B, I believe it's B21. So if you come in and lie to me about who you are or that you haven't received the same substance and try and get me to write a prescription, there is no right to privacy. And I assert that the same would hold true if you're attempting to deceive voting officials. Someone else mentioned the issue of homeless shelters. If we don't have some sort of check and balance, then everyone in the world, all 7 billion people, can come to New Hampshire and claim they live in a homeless shelter and they want to vote. If you're not going to hold people accountable, then there are no voting requirements in New Hampshire. Anyone and everyone can vote. And I don't think that that's what you're really striving to achieve by saying we're not even going to have homeless people have some form of documentation. Someone else mentioned a concern, I believe it was the moderator from Derry, about maintaining lists. We already have lists. People who vote by absentee ballot have it marked right on the voter registration list. It says AB, and it's on every single page. We already have these lists. She also mentioned that it would be an incredible workload to, quote, reopen all these boxes. These affidavit ballots are hand counted. They should go in one box. You will not have to go and reopen every single box of ballots in order to retrieve them. They should be segregated the day of the election. And finally, the example was given of the elderly man who has been here for 50 some odd years and has no photo ID. Does anybody have a problem with someone not being able to obtain a photo ID in 50 some odd years? Right now, it is a New Hampshire law. You have to produce a photo ID in order to vote. Are we supposed to just ignore that out of inconvenience to someone, or do our laws actually mean something? I thank you for your time, and I'd be happy to answer any questions.
Questions? Senator Perkins Coker.
Yeah, thank you for being here today. So contrary to, I guess, what other folks have testified here today, do you have evidence of voter fraud occurring in New Hampshire?
I worked with Senator Gaida on this bill, and we met frequently with Secretary of State Scanlan, former Secretary of State Gardner. Secretary of State Gardner has many examples of people who have voted illegitimately. Again, the Attorney General's office is still working on 2020 data. The last election that we have, I guess I would say, settled data from is 2016. And in that election, a woman who is a Massachusetts resident was caught voting in Plymouth, New Hampshire, visiting her boyfriend at PSU. She admitted that she had broken the law. She paid a $500 fine. That's hardly a deterrent. Secretary of State Gardner has numerous other examples of people who would fly here from Florida, despite being Florida residents, and vote in their prior locale. He's got quite a few examples, so I think when we have an opportunity to hear from former Secretary of State Gardner, he can give you much more specific data than I can.
And thank you. One follow-up, Chair. Are you aware that there's actually a right to ballot privacy that's protected by the U.S. Supreme Court?
Okay.
Okay. Thank you.
Additional questions? Thank you, Doctor.
Thank you.
Brenda, I'm not exactly sure what you put at the end, whether it's an EI or an U or, so I didn't try.
Okay, really bad handwriting. It's after raising 4 kids, you just kind of lose a grip on that. Anyhow, thank you, committee, and thank you, Chairman, for hearing me today. I am Brenda Town. I'm a business owner, and I am also, I run a large business unit for contract manufacturing, have 4 kids, 3 in the military, and... Sure. This is the best part, and 8 grandkids. Okay. So this past fall, I started to participate with a very large group of people who are the group that gets talked about, the ones that are concerned about election integrity. And we started a statewide citizens audit. We executed 243 plus FOIA requests and have pulled all of the records from every town. To complement that, I led a canvassing group, and we started canvassing in a couple towns. And instead of going down any of the paths that the prior speakers discussed, I just wanted to discuss the canvassing results to date. In front of me here are affidavits for homes that we canvassed that the people in the homes did not vote. So people voted on their behalf. And so what we've found so far is almost 15% of the homes that we got people to answer the door were people that did not vote in the election. So included in that are same-day voters. As far as the consequence to our state, if we were to extrapolate our canvass base, which was just about 800 folks, that would mean that 1% of all of the votes, because that was our experience, 1% of the people that we got responses from had same-day voters vote from their homes that really weren't residents of those homes. So I'm here to tell you that this is a problem. There is no hand-waving here that this doesn't exist. There is a problem. We will finalize our affidavits to share that, and it's a cry of our heart that we address the process gaps that we have as a state. We just really are looking for every voice to be heard. And if 1% of the people in the state of New Hampshire are having their voices canceled out by people who shouldn't be voting, then that is a truly huge, huge problem. So thank you. I'd be glad to take any questions.
My recommendation on your documentation is that the originals go to the Attorney General. Copies can be distributed to the committee and also the Secretary of State. But the Attorney General would be the one that would be conducting any investigations.
Okay.
Questions from committee members? Seeing none, thank you very much.
Thank you.
Ken.
Hi, thank you for the opportunity to speak. My name's Ken Eyring. I live in Wyndham. I just got some notes that I scribbled based on testimony that was given. And, you know, first of all, I just want to thank you for the opportunity to speak, Mr. Chairman and all the senators here. I also want to express an enormous gratitude to Senator Guida for putting this bill in. This is something that's a long time in coming. I've been sworn in as a same-day voter registration person multiple times, and I have to assure you that most people come with their identification for who they are and where they live, and that they're a U.S. citizen. Yes, there are some people who sign an affidavit, but if we have 100,000 people in an election that register on the same day, you're not going to have 100,000 people that you're going to need to expect them to provide any kind of documentation or proof after the election in order to verify their affidavit ballot was cast properly. So, you know, there is a reason to be concerned. I heard that comment made at least once during previous testimony that there's really no reason to be concerned because the numbers are so minor. Well, if you look at the beginning of Senator Guida's bill, as an American citizen, that comes with responsibility. And that's one thing that all the arguments that came up here today that oppose this bill, they dismiss the fact that people have personal responsibility. And what the arguments are stating is that our laws should be written to accommodate their lack of addressing what their responsibilities are. And there's many, many different examples. You could talk forever. That's not the purpose of this. The purpose of our voting is for people in our country to vote and then elect who they want their representatives to be. People lie. Happens all the time. But what's being suggested by the people who have come up here and oppose the bill, they're suggesting that we need to believe them. Why? It's not difficult to show an ID. Dr. Strang gave a perfect example. You're not going to get on a plane without an ID. You're not going to buy beer without an ID. I could go on and on. It's hundreds and hundreds of examples. But somehow we are supposed to just kowtow to all these people who say, well, it's insult to people. There's no cost too high to ensure the integrity of our elections. None. If one illegal vote is cast, it disenfranchises one legal vote. That might be the vote that decides one of those 44 elections over the past 45 years. The homelessness issue was addressed. The issue of the ballots being counted was addressed, and pulling the ballots. So another argument was that, well, people will lose their right to privacy. With all due respect, how dare anybody protect someone who illegally voted and saying they have a right to privacy? And if they choose not to, and even if they are legal voters, but they forgot their ID, if it's not important enough for them to take the time to show that ID within a 10-day period, then they lose their right to vote. That's on them, not on us. Don't put everybody else's votes in jeopardy and the integrity of our election in jeopardy simply because somebody didn't do their job and provide their responsibilities to provide the documentation that's required by law. When I was sitting there in Windham as a sworn-in election official, it killed me to see that people could literally come in with nothing, sign a document, and go over and vote, and their vote counted. That's not right. Senator Guida took the time with Dave Strang, with the Secretary of State. They tried to address every issue. They addressed the issue in the Constitution that the votes have to be counted on Election Day. That's happening. But it doesn't mean that those votes, if they were cast illegally or not with the proper, not by properly registered voters, it doesn't mean that those votes should be certified. So that's what this bill is all about. It's trying to protect everybody's rights. And with that, I'll end my testimony. I appreciate the time that you gave me to talk. You know, I believe that everything that Senator Guida said was spot on. I appreciate all the time and effort it takes, you know, for him to write this bill. I appreciate the words that Dave Strang expressed. He addressed a lot of the things that were on my mind, and I just want to again thank you for allowing me to take the time to express my concerns as well.
Questions from the senators? Senator Burton.
Thank you, and thank you for coming up, Ken. I appreciate it. I know earlier, based on what you had said, that, you know, if someone casts an illegal ballot, it disregards a legal ballot. I know there were a number of, the League of Women Voters named a number of individuals who violated the law and were found guilty. Would you not agree that they, even though there were 5, 10, 15 of them, they disrespected other voters?
How many times have you heard your vote counts? Your vote's only one vote. So does it count or doesn't it count? Should it count? Absolutely. Everybody's vote counts, and it should be given the proper due respect and protection of the law. And if people are voting illegally, or they haven't done their due diligence because of their personal responsibility, let's not forget that. If they don't want to take the time and effort, and it's minimal, don't buy into that narrative that it's very difficult for these people to provide the documentation or to, you know, go through the process. We all have to do that. We're all adults. We're talking about electing the people who are going to represent us in our government. It's one of the most important things we can do during every election. We need to ensure the integrity of our elections are of the utmost impeccable and unquestionable, especially since New Hampshire is the first in the nation state. We don't want anybody questioning whether our elections are accurate or not. I hear it's $2 billion worth of revenue every time we have a presidential election. That's an important aspect and fact to consider regarding the integrity of our elections.
Okay, seeing no more questions, we have one more person. Looks like Bandano.
Right on.
All right.
Thank you so much for this opportunity. First of all, really important.
Introduce yourself.
Oh, my name is Al. My name is Al Brandano. I'm a resident of Kensington, New Hampshire, and I'm a citizen of Kensington. I'm it. 33 years in a small town. We know everyone. We like everybody. Town clerk, moderators are all friends, personal friends. This became very difficult for me because I was hearing all this stuff about, you know, voter fraud and all this. And I said, you know what? One day I'm driving by the little local park and we have a flag up. And in that flag is an honor to Andrew Nicole, who's a 5-time Army Ranger. I'd never served in anything and never been part of the military, but every time I go by that flag, I know I have to do something. So I went to the town clerk this last time and started asking questions, and the town clerk gave us, the town gave us an attorney to work with, and we worked through the town clerk and the attorney. And when you say that, or I heard today that there is no fraud in election, I just want to refer to, and I'll give this to you as testimony, January 7th, Bernard H. Campbell, Esquire. It's the response to a follow-up question to the town of Wyndham election. It's from William Gardner, so when he comes, maybe you can ask him. I will quote, Wyndham election night results were not just imprecise, they were fundamentally flawed. I will produce this document for you. So there's way more than meets the eye. What the governor said in the very beginning, you know, he had no knowledge of this. No one did. This just came out on January 7th. But let me tell you why I lost faith and trust in elections. The big part for me is the audit process. What I really learned, and this is with the help of the town, is it was alarming to me. There's no chain of custody requirement for memory chips or cards. There's no software security review or defined specifications. There's no audit capability as defined by the legislature or state law. There's no best practices audits for town clerks, moderators, and as we heard in the other hearing, it's voluntary. They don't have to attend. There's no testing against controls. The last security update on the machines was done in April 9th, 2010. I ask you, and I'm the face of those people who have lost trust. And I've done just a preliminary review for the town of Kensington. I'm asking you to be bold and unite us. We are divided. If you look at the statistics in voting, 50% of the population doesn't believe for whatever reason. But my little town of Kensington, my little test told me that I can't trust but verify. We need to do that, and you need to be bold and act boldly on this bill, in support of this bill, so you can help and unite us. It needs to happen. I'll take any questions.
I just want you to verify because there are people that are listening online. It sounds like that is the letter from the Attorney General and Secretary of State to the town of Wyndham.
That is correct. It's to Bernard H. Campbell, Esquire.
Yeah, I just wanted to make sure that people, if they wanted to know what you were referencing, that they could.
Yep.
Questions from the senators? Seeing none, thank you very much.
Thank you.
And we'll close the public hearing portion of this right after Senator Guida has less than a minute to rebut, but.
Thank you, Mr. Chairman, members of the committee. As I stated initially, this is a bill that is critical to the integrity of our elections and the trust of the public. Okay? It establishes no greater requirements than already exist. It's predicated upon existing law. And I think perhaps the best testimony was that of the lady in the back who is working as a citizen and is discovering significant indications of certainly unqualified voters. I hesitate to use the term fraud. That's a crime. This bill is not targeting fraud. This bill is targeting making our election process as good as it can be. I would caution the committee, in the words of my dearly departed friend Rogers Johnson, let's not make the perfect the enemy of the good. This bill isn't perfect. I'm willing to amend pieces of it that are concerning. But it's a bill that's necessary because it closes a gaping loophole in the election integrity of our state. And I thank you.
Thank you, Senator. Public hearing is closed. Just scheduling stuff for the committee members. There's a couple of different schedules out there, so watch out since we didn't have a meeting on Martin Luther King Day, and we also had the House bills. I've tried to schedule 2 of the minor redistricting House bills, the county commissioners and the delegations, so that we can get those out of the way, because I don't anticipate that there will be a large attendance. And then we have House Bill 50, which we're scheduling.
Excuse me, we're still meeting?
Well, quiet in the room, please. So we scheduled that for Reps Hall. We will try to do anything else that, the big bills at that same time that need a public hearing. I know that there may be amendments coming from one side or the other in this, and certainly we want to give people at least some time to be able to do it as much as we can. And with that, are there any comments from you guys? Good night. See how well my egg works? You know, come on. Makes lots of noise. Where do you want to meet? Here, upstairs?
Upstairs is fine.
Okay.
I can just throw my stuff in the office, I'll go upstairs.
Yeah, I need to make one stop on the way.
That's fine.